Empower, execute.
As Odie said, my name is Laura Rogal. I'm an attorney with Jayberg & Wilk. My areas of expertise are intellectual property litigation and internet law. I'm the former chair of the e-commerce and technology section of the State Bar in Arizona, which means I do a lot of talking to people on a regular basis about business and in particular online business. So when you're registering a trademark, you have a bunch of options. They've got, well, let's first take a step back. Odie's talking about registering a trademark with the United States Patent and Trademark Office. You can register a trademark in the state of Arizona, but all that does is it registers it with the Arizona Secretary of State's office, and it gives you pretty much no protection whatsoever. It basically says, okay, is there any other trademark in the state of Arizona that uses this name? No, fantastic, you've got an Arizona registration. But it doesn't have the same enforcement mechanisms as registering with the United States Patent and Trademark Office. You can only try to enforce it in the state of Arizona, but if someone has that registration with the United States Patent and Trademark Office, they can prevent you from using it in Arizona, even though you registered with the Arizona Secretary of State. So whereas they like to take your $10 and say thank you, it's not very useful to do. The only reason to do it would be if you want to put someone on notice that you might start using the mark, but again, it's still probably worth it to register with the USPTO. When you're registering with the United States Patent and Trademark Office, you've got to put down descriptions of categories of usage of the mark. And so what that means is, let's say we've got a mark, OD's tax service. We'll go with Y's tax services, okay? And we're gonna use that as the mark. He needs to explain to the USPTO what that mark is gonna be associated with, because when you register a trademark, you only get protection for the areas that you're actually using the mark in. So Y's tax services isn't going to be used in connection with restaurant services, for example. It's not gonna be used in connection with the sale of consumer goods online. It's for tax services only. And so you need to figure out what categories it fits into. And there's actually a list of options that are on the USPTO's website that you can use to describe your services. However, this is really important. If you plan on expanding your mark to other services or other goods, you need to make sure that you're encompassing that when you're doing your registration. So for example, let's say OD has a plan to expand his tax services into legal services and legal offerings. He needs to make sure that he registers his mark for both of those categories. Or he's got a plan for expansion into speaking engagements or for education and training services. That's another one of those categories. So he needs to make sure that when he's doing his registration, it encompasses all of those categories so that you're not stuck later on and find out someone else when you're going to move into that area, when he's finally had that natural plan of expansion. He gets there and he goes, oh crap, someone else already is doing that under that name because I didn't remember to register it when I first did my registration 2 years ago, 5 years ago, whatever it is. And so unless it's a natural area of expansion, it's really hard to go back in time and say, oh yeah, I really meant to register it for that, I just sort of forgot. So that's one of the things that you need to take into consideration when you're doing your sort of categories of registration, registering that trademark. Did that answer your question? With a little too much information, I'm sure. Yes. So what the Trademark Office looks for is you have to prove actual use of the mark. You can also register under an intent to use, which means that you have 6 months to show that you've actually started using it. And you can extend that usually for another 2 terms. So you can get it for about 18 months to hold a registration. So let's say you intend on starting a business sometime in the next 6 months under a particular name, John's Car Service. You can register that right away, even if you haven't started your marketing plan, even if you've just started started putting together a business plan. But you came up with a really good name, you can put it down and put down every category that you think you're gonna go into. The thing that you need to be careful of is that some of the categories on the USPTO's website are really, really specific and some are really broad. And so the mistake that people make is they try to be way more specific than they need to be. So you don't need to take, okay, it's a car service, it's a limo service, it's a taxi service, it's a livery service. You don't need all of those. If you just picked car service, that encompasses all those subset of categories, and you don't limit yourself to that one niche. Because as long as you've got that big broad category, you don't really need the specific categories. But that's the mistake that people make, is they'll pick the really, really particular ones, and then they do one thing that steps them outside of that, and then that's where they try to enforce the mark. So let's say you picked livery service as the identifier for your category, but then you wanted to expand to a taxi service, and so you're now using John's Car Service as a name for a taxi brand, and someone else's John's Car Service comes in and you try to enforce it against them. They're going to say, no, you said you were a livery service. That's totally different than a taxi service. But if you just pick car service, that would have been that all-encompassing thing. So you need to think about it. And there's lots of attorneys out there who can give advice on this. The other way to learn about it is to just look at, some really famous brand names, or even like known marks in that area that you're looking into, and see what they registered it for. The USPTO website is completely free to search, and it's really easy to search. It's got 3 different types of search options. You can use Boolean search, which is those connector searches. You can use just generic string search, which is more Google search like. And so it's really easy to search and see what other people have used and how other people have registered their trademarks, and you kind of can get a good idea. Okay, so Discount Cab, what did they register? How did they register that? And look for those and kind of take ideas from those. You can also always amend your trademark registration, which is really nice. So let's say you need to expand your area. You can do that. They'll let you do that, because every 5 years you have to update your trademark registration anyways. So with copyrights, you automatically gain a copyright interest in every artistic act that you do. So just the taking of your picture, you've got a copyright in that picture. So you're golden. The only difference between registering a copyright and not registering a copyright is the enforcement mechanisms. And the biggest difference with that enforcement mechanism is getting your attorney's fees versus not getting your attorney's fees. You can always enforce your right in your copyright, whether or not you've registered it. But if you need to take it to that next step and hire a lawyer and actually go that route, you're a lot better off registering it, because then when you're enforcing it, you can ask for your attorney's fees. The other piece that you can get with that is statutory damages. So if you don't have a registered copyright, you can only get actual damages. So if you take a picture here, you post it on the website, someone's taking it and they put it on their Facebook page. What are your actual damages with that, right? Probably not much. Maybe 1/16 of your time spent here, of the value of your time spent here. I mean, it's not going to be a big dollar figure. But if you had registered that, arguably you can get statutory damages for it. Are you really going to go, hire a lawyer to get $350 or $7,500 just because one person put one picture? That's up to you. It depends on what precedent you want to set. But those are the two key distinctions. So if you're doing a bulk of work and you're doing a lot of work and you're finding, oh dear, people really like my pictures and they're really stealing them, you might want to think about registering them. And there's different ways that you can register them. There's different actions that you can take with registration. You can do a bulk registration, a compilation is what it's called, or you can register each individual picture. So you might look and say, okay, people are really, every event I do, people seem to take these 5 type of pictures and always steal them. So I'm going to register those 5 pictures from every event that I do and see if that, if that gets you anywhere. Another enforcement mechanism that you can use if it gets published online is what's called a Dmca Notice. Has anyone heard of a Dmca Notice? Am I using magical words here? Okay, so DMCA is the Digital Millennium Copyright Act, and it actually is for the enforcement of copyright protection online. And so what it says is, the host of a website can't be held responsible for someone else's copyright infringement on the website. but it puts the onus on the host of that website to take down any infringing content. And so if you are the host of a website or the operator of a website, you actually have to register with the United States Copyright Office and have what's called a DMCA agent. So let's say you find your picture on someone else's website, you can't figure out how to get it taken down. You can go to the Copyright Office's website, find the DMCA agent for that, and do what's called a Dmca Takedown notice. It's very simple. It's got 4 elements to it. You basically have to say, here is the infringing content, here's where it's located, I swear under penalty of perjury that I own the copyright to that content, and then you send it off to the the DMCA agent. The DMCA agent then has an obligation to take down that infringing copyright. So if they don't take it down, then you can go after the website itself. So the nice part about it is it's what's called a safe harbor provision. You say, hey, website, you have stolen content that's mine on your website. You need to take it down or I'm going to come after you. And the website host is usually like, oh, okay, we're going to delete that picture. It's not worth it to me to have that picture up on my website just to avoid, and have that third party who posted it up there, make them happy. I'm going to take it down and it's going to be a lot better. So using that DMCA tool is a really helpful tool, especially for photographers. It's also a good tool for business practices. What we found is that a lot of times competitors will take content from a competitor's website and put it on their own website. And they'll say, hey, look at this terrible product. This product's so awful, and here's all the bad things about this product, which is arguably acceptable to do, except for the fact that they took your picture from your website, right? So it's a little tricky way to get content taken down from a competitor's website by saying, hey, I own the copyright to that picture because I signed an agreement with the photographer when the photographer gave me that picture to put on my website, so I have the license to that. I have an exclusive right to use that. So I can get that website taken down from my competitor's website, that picture taken down from my competitor's website now using that DMCA notice, using that DMCA tool. So there are these little tricky tools that are out there that are completely inexpensive. Like I said, doing a Dmca notice, all that information is freely available to you. And so all of that's out there, but that's a tool that you need to know that you have in your arsenal. It doesn't require a lawyer. You can hire a lawyer to do it. It's not expensive to do. But it's a useful tool and it's a useful practice to recognize that that's out there. So photo release, absolutely. So you cannot transfer a copyright unless it's in writing. So there is no such thing as an assignment of copyright, a license of copyright, any method of transferring any interest in a copyright unless it's in writing. This is like the only thing pretty much in the history of US law that absolutely unequivocally requires that it be in writing, except transfer of land. That's the other piece. But those two things are pretty much the only thing where there's laws that say it has to be in writing and there are 0 exceptions to it. So in order for there to be that license, and there's many ways that you can do it. You can have an exclusive license. You can have an unexclusive license. You can have a right to use. There's lots of ways that you can transfer that interest. You can also have an unexclusive license plus a right to enforce copyright. So you can transfer as the photographer, you have the ability to say, I'm not going to give you an exclusive license to use the photographs, but I am giving you a right to go enforce my copyright on my behalf. Because the two of you want to share that interest, and both of you have a vested interest in those pictures not being used by someone else. But any of that, it all has to be in writing. And there's no magic language. It's helpful if it says license to use photographs or exclusive rights, something along those lines. When you don't use the word copyright in there, or you don't use the word license, or you don't use the word assign, it gets a lot more difficult. I'm litigating a case right now where someone's trying to claim that a letter from his mom to himself constitutes a transfer of copyright, and we're on the other side of that. And so we're saying that the word copyright's nowhere in here, the word license is nowhere in here, the word transfer is nowhere in here. You just say that here they are. And so physical possession means absolutely nothing with respect to copyright, especially nowadays when everything's pretty much digital. Physical possession, that whole ownership is 9/10 of the law, or possession is 9/10 of the law, absolutely has no legal bearing with respect to copyright ownership.
So two-part. there, I run a digital magazine as well. So when I get the photos from the photographers, I need to have a licensing agreement. I need to have, now I noticed you said transfer needs to be somewhere within there, but you said you can't transfer copyright.
No, I said you can't transfer copyright unless it's in writing. He absolutely, the photographers absolutely can transfer the entire ownership to you. Typically, photographers will refuse to do that because they want to hold that ownership. But what a lot of times they'll do is they'll give you an exclusive license. Say, you're the only one I'm going to give a right to use this to other than me. And so that's how they'll do that. So I was giving you a number of options of way that you can do that. So you can transfer it, but it has to be in writing.
Photos. So if you reference the photographer and you use the photo, are you still okay in using that photo? Or if I take something from someone else, but you're acknowledging this is Carlos Tolliver's work and you're using it on maybe your website?
No, you have completely violated their copyright. So there's what's called fair use. Fair use is a defense to copyright infringement. If you simply take someone's photograph or picture and you say, well, this is they're the photographer, that's not an acceptable defense to fair use. The only typical acceptable defense to fair use would be if you say, hey, there's this great picture, I'm going to give you a link to the photographer's website. Then that's fair use because you're not actually taking their picture, you're not taking their copyright, you're just referencing back to it. So that's an acceptable reference back where you're not going to be infringing on your copyright. The same works for literary content. So there's two ways to, sort of carve out the exception, the copyrights exception to using literary content. One is if you're commenting on it. So if you use, let's say, a block quote and you're giving a narrative explanation about why you disagree with what that person said, that's going to be fair use, right? So let's say you wrote an article on your website and I take a paragraph from that and I write my own article explaining why I think you were terribly, terribly wrong. That's going to be fair use because I'm not copying your content for a commercial purpose and using it. I'm actually doing it for fair commentary, which is an acceptable use. But if I just copy your entire article and put it on my website and I have a one sentence thing that says, wow, isn't she terribly wrong? That's not going to be fair use. There's not going to be that exception to it. So there is a balance. A lot of it has to do with how much you take in terms of literary content. If I take 2 paragraphs from you, arguably, I've taken it outside of there. If I'm using it for an educational work, however, let's say I'm publishing a textbook or I'm publishing a law review article, then it's okay as long as I reference back to it. So there are these little carve-out exceptions to it, but you do have to be very careful with what you're using. And the solid answer is, when in doubt, ask for permission. Because most people will give you permission to use their content, and they usually won't charge you for it. But they want to just appreciate that you recognize, hey, I worked hard. Like, I spent time and effort developing this skill set to take pictures or write articles or whatever it is. And they just want to know that you recognize that and just get that little shout out wherever it is that you're using it. You as a person sitting out in the audience have absolutely no right to not be in the video that's being taken today. So if you're here today and the video is being taken and it gets up on the YouTube, you have no right to say, ooh, I want that taken down. I have some sort of interest in it because I'm in that video. So that, you don't, in terms of having that, image release and that sort of thing, not actually a big deal nowadays. Arizona actually just recognized a right of publicity about 2 months ago in a Court of Appeals case that actually got litigated by my firm. It was a weird case. It got litigated in the context of probate court, which means that someone was deceased and then 2 family members were fighting over whether or not they could use something of their mother's for commercial purposes. But in that context, Arizona finally recognized right to publicity. Before that point in time, there was no right of publicity in Arizona, which meant that I could take your picture, put it on a billboard advertising whatever it was that I wanted, and because I took your picture, I have the copyright to that, right? So just because you were in it, if you were walking down the street and that's when I took your picture, you had no expectation of privacy and not having your picture taken. So that's a little bit of a disconcerting thought to a lot of people. They don't recognize that, okay, when I'm out in public, as long as I'm not in my house, I have no right to privacy. I have no right to say, you can't take my picture. You have no expectation that your picture is not being taken, and no expectation that it's not going to be used potentially for some other purpose. If it's being used in a commercial manner versus a non-commercial manner, there's a slight difference. You know, no one can take your picture nowadays in Arizona with this new right of publicity. They can't take your picture and put it on a billboard and say, oh yes, you know, Laura promotes smoking because it's a fantastic thing. I would be able to sue them for that because that's a terrible concept for me to be promoting. But before, you know, 2 months ago, that could have happened. But with respect to OD's question, where he says, well, okay, you have to affirm to YouTube that you have the copyright. All YouTube is asking is, did you take the video, or do you have authorization from the person who took the video to post it on there? Those are the only questions that they're asking about with respect to, do you own the copyright, or do you have authorization to publish this content? So that's all that they're really looking for. YouTube has a lot of issues with copyright infringement. The good thing about YouTube is they also have really, really, really good takedown policies. So YouTube's owned by Google, right? Everyone knows that. So Google has this whole takedown process. It's a really nice fillable form. If you find any content that's infringing your copyright, your trademark, anything along those lines, any other business rights that you think that you have, they have a fillable form that you can go through and fill out and get a lot of content taken down. So it's a really helpful tool. And there's a lot of those like little free tools out there that people don't recognize or think about that are available to you that you don't necessarily need a lawyer to do. Same thing in California, that's where most of the celebrities are having their photographs taken. California also recognizes a right of publicity, but there's a fine line there. So it's whether or not you're using the photographs in connection with marketing commercial material. So if they're just putting it, so when all the photographers use it and put it on like TMZ or put it in People magazine or anything like that, arguably they're not using it for a commercial purpose. It's a news event because that person is a public figure and what they're doing is considered news. And there's tons and tons and tons of cases that talk about that. There's actually a really cool case that came out of California about 15 years ago that dealt with Barbra Streisand, and it actually developed a rule of law that's called the Streisand Effect. So Barbra Streisand was building this like ridiculous house on the bluff, and some aerial photographer took pictures of that property. And she filed a lawsuit to try to get those pictures, you know, take those pictures away, said, I have a right to privacy, you know, you can't take pictures of what my house looks like, this is a terrible thing. As it turned out, the outcome of that case doesn't matter, because what happened is she turned what was really like a quiet, private thing into this blown up news event. And so that's what we call the Streisand effect, right? Is a lot of times when you have someone take your picture, it's buried, right? It's not really public, it's not really out there. But once you file a lawsuit about it, it's gigantic news, right? It's part of the public record. It's going to be out there forever and ever and ever, and it's easily searchable and locatable. You can't get to it. And so that's what we call the Streisand effect. It's one of those things you have to make that business decision. Is it worth it to turn a little something into a gigantic news event, or is it maybe something that you can get to go away on its own? And I think we're done. Thank you.
Ready, set, go! Educate, empower, execute!